Good evening and welcome once again to another program of Issues in the News, where we discuss the important events that would have taken place in our country over the past week or so. And as you know, we are experiencing some technical difficulties, but we are improvising and we are still able to contact you through another mechanism. So we are here, and that's what is important. So I still would like you to press that share button on your phone, press that share button on your computer, ensure that everyone is joining us, everyone on your wall, everyone on your page is joining us as we build the widest possible audience. I will try to join you live at a later stage so that I can see your comments, but it does not matter. What matters is that we are communicating and the show is on the road. So please press that share button, ensure that we build the audience, ensure that we build the viewership, because we have some important issues to discuss tonight. I want to begin by observe that one of our most ardent viewers of this program, Bibi Sephora Shadiq, is no longer with us. You must know this by now. Ms. Shadiq passed on Saturday and was buried the following day, Sunday. Ms. Shadiq was, as you would have heard by now, a retired teacher. She was a lawyer. She was a minister of the government. She was a parliamentarian. She was a GCOM commissioner and played a significant role in defending, promoting, and preserving democracy in this country, in particular during the last elections and the events that succeeded those elections. Shadiq lived an outstanding life, and she demonstrated very clearly the heights to which one can rise from humble beginnings on the island of Leguan, born in abject poverty. She won a scholarship very early at age 11 to attend Bishop's High School, and from then she did not look back. She studied her entire life. She taught for most of her life and shared the knowledge and experience that she would have acquired over the years and served her people, her government, and her country with distinction. This program wishes to pay tribute to her legacy and also to extend to her family, relatives, and our deepest condolences. She will certainly be missed, but I take cognizance, I take solace rather, from the fact that she lived a full life, she lived a satisfactory life, and she lived a life on her own terms and conditions, as I said on my Facebook page. Following the passing of Bibi Shadiq, obviously a vacancy would have been created at the Guyana Elections Commission. And today, Comrade Clement Rohi, a stalwart, a leader of the People's Progressive Party, and a former commissioner of the Elections Commission in the 80s, in the 1980s. He was sworn in today by His Excellency the President to fill the vacancy created by the death of Bibi Sephora Shadiq at GCOM, of course representing the government's side. As you know, GCOM is made up of 3 government commissioners and 3 commissioners coming from the opposition. They are appointed by the President upon the advice of the Leader of the Opposition in accordance with the Constitution. And then of course you have a chairman or a chairwoman, if you wish, who comes from a name, who's a name coming from a list of 6 persons submitted by the opposition leader to the President for appointment. So it's a very equally balanced commission, with the chairman having a casting vote, and that is why that chairman position is so important. At the swearing-in ceremony of Clement James Rohi this morning at the office of the President, the press asked Chairperson Claudette Singh to respond to contentions by Aubrey Norton that she must tender her resignation. And I think that the chairperson, she must tender her resignation because she makes decisions that are supportive of the People's Progressive Party. Now, first of all, GCOM is an independent body and cannot be coerced, cannot be intimidated, and cannot be forced to make decisions by any politician. GCOM makes decisions by votes, and that is stipulated in the law. The chairperson of that commission ought not to act under duress, cannot rather act under duress, and no one should attempt to influence constitutional office holders in the discharge of their functions. And that is what Aubrey Norton wants to do by demanding the chairman must resign. And why? Because in his view, the chairman votes with the People's Progressive Party. Well, the chairman responded, I am not here to defend the chairman. The chairman said that her decision is based upon law. How can one fault such a position? One can only endorse such a position. I have repeatedly made the point on this program, and almost every time I speak on the question of elections, that elections is a legal process. It's a statutory process. So once one upholds the law, one will always act in accordance with how election decisions are to be made, because they are all laid down in the law. So if the PPP is doing the legal thing, whom do you want the chairman of the commission to agree with? Those who want to subvert the law? Those who want to subvert the Constitution? Those who want to deny the will of the people? Those who want to pervert the votes of the voters? Because the law and the Constitution outlines how elections are run and how votes are to be counted and tabulated. So if there is a vote to be taken and the PPP is on the side of the law and the chairperson of GCOM supports the PPP, acts lawfully, she will be on the side of the law. No one can be faulted for being on the side of the law. The PPP is taken to court. The court rules in favor of the PPP or rules in favor of the government. Are the judges biased too? Is the entire international community biased? Is the entire CARICOM biased? Is the CARICOM team that Mr. Granger certified to be the most legitimate interlocutor and most qualified to observe the recount, are they biased too? The 100 governments across the globe that stood on the side or with the PPP in respect of the 2020 elections, are they biased too? So again, Mr. Norton speaks and he puts his foot in his mouth. And he seemed to be doing that on every occasion that he speaks. And I thought that I would highlight the chairman's position because, as I said, I don't have to defend the chairman, and I am not defending the chairman. I am defending constitutional office holders being allowed to function in their office with due autonomy and free from intimidation and influence. That is what the Constitution says, and as Attorney General, it is part of my duty and responsibility to ensure that the Constitution of this country and the law is upheld at every forum. And that's what I'm doing. Now, it has been drawn to my attention that the APNU AFC parliamentarians who were suspended in particular, and those outside of that grouping of 8, have repeatedly said in the public domain that they were denied natural justice in their suspension in the parliament. And I have heard that repeatedly said. And persons have asked me to respond. Now, it is already common ground that the Parliament is subject to the Constitution, but is authorized by the Constitution to regulate its own affairs and to make rules for the regulation of those affairs. Those rules are called standing orders. Our Parliament, like every parliament of the world, has promulgated standing orders which govern the internal workings of the Parliament, which regulates the business of the Parliament, and which determines how parliamentary procedure is to be conducted. The Constitution also says that Parliament is independent of the judiciary and the executive. And when Parliament regulates its business, it's only if Parliament violates the Constitution that the court can intervene. That Parliament has an independent aura that authorizes it to be the judge of its own business. Not only to regulate its own business, but be the judge of its own business. Parliament, in this independent aura, has the authority to discipline its own officers. It has the authority to enforce its own disciplinary code. All of those things Parliament is entitled to do in a parliamentary setting without the interference of external agencies, including the court. And it is for that reason that parliamentarians have immunity from suit. Parliamentarians, regarding what they do and what they say in the National Assembly, they can't be sued criminally, neither can they be sued in the civil courts. Now, if you are empowered with that kind of privilege and immunity, then it comes with it some degree of responsibility. And that is why, if you have that power and that privilege when you stand in that parliament, you are also at the same time bound by the rules of that parliament. Because it's that very Constitution that says that the court can't charge you, the police can't charge you, nobody can sue you for defamation for what you say in that parliament. Well, that very Constitution also says that Parliament must be responsible for your conduct, and Parliament, and only Parliament, can discipline you and determine how you must behave in a parliamentary sitting. It cannot be doubted, as the whole world saw, the way in which these people behave on the 29th of December 2021, when the Natural Resource Fund Bill was being debated. They behaved in the most disgraceful and vulgar manner. And a motion was moved, and they were taken to the disciplinary committee of the parliament. That disciplinary committee is called the Privileges Committee. The Privileges Committee is made up, it's appointed at the beginning of every parliamentary session. It is chaired by the Speaker, and it is made up of members. Now, the disciplinary committee or the Privileges Committee is created by the standing orders, and its rules and regulations are contained in the standing orders. So when you go before that committee, law doesn't apply. Standing orders apply. And that is what they don't understand. But the standing orders also have due process in it. The standing orders were made by the very parliamentarians. It has in it due process, very similar to a court. But the court has no business in the parliament. And there are certain peculiar things about a parliament that differentiates it from a court hearing. So, we parliamentarians sit as members of the disciplinary committee, and it is chaired by the Speaker. Now, it is the Speaker that has committed them to the disciplinary committee. It is the Speaker's order with directions that the Privileges Committee deal with the matter. The Speaker is also the chairman of the committee. So right there, you have something that can't happen in a court, where the judge is now part of the proceedings that he has ordered. So he becomes really almost a judge in his own cause. But those are the peculiar characteristics of Parliament, because it is the standing orders that say that. Manzoor Nadir didn't decide that he will impose himself there. The standing orders say how those proceedings must be constituted. And when standing orders are violated, they can't be enforced in a court of law, because a court of law is a court of law, it's not a court of standing orders. Standing orders are not law. Standing orders are mere rules of a parliament. They're not passed by the parliament in its legislative, functional power. They are passed by the parliament exercising an administrative function, not a legislative function. So the process by which laws are made are quite different from the process by which standing orders are made. And that is why a court has no jurisdiction to enforce a standing order. Courts enforce laws. That distinction must be appreciated. So when they went before the disciplinary committee or the privileges committee, we had to look at what the standing orders say in relation to due process. They were all told in writing what they were brought before the privileges committee for. It is in the motion that committed them to the privileges committee. So they were told in writing what they were there for. They were then afforded an opportunity in writing to show cause in writing why they should not be found guilty of that which they were accused of. And they were given time, 2 or 3 weeks or nearly a month, to respond. They responded by letters. Each of them responded by letters. Right there is the hearing. A hearing doesn't necessarily have to be an oral hearing. A hearing means you are being afforded an opportunity to put forward your case. It can be done orally and it can be done in writing. They were afforded a hearing in writing, and they took advantage of it because they wrote in response. Of course, they wanted to lead witnesses and they wanted to know who will be leading witnesses, evidence against them. Those were the questions that they also asked in their letter as they attempted to plead their evidence. Now, the Parliament is not structured the way that it will allow for evidence to be led and lawyer to cross-examine witnesses. And in this particular type of case, you needed no evidence because it was contempt committed in the face of the Parliament. Meaning that it was contempt committed in the presence of everyone. And yes, we who constituted the Privileges Committee were in fact the witnesses and the judges. We didn't make that rule. That is what the Parliament made as the rules. Those are in the standing orders. And Guyana's Parliament and standing orders are no different from parliaments and standing orders in every part of the Caribbean and the larger Commonwealth. So there is nothing unusual. So who are you going to cross-examine? We want to make the Privileges Committee a circus? I, who sat on the Privileges Committee, saw what you did. And I have a videotape and a flash drive to support what I saw. And you also have it. It's on the Parliament website. So what is it that you want to, what is it that you want to know? What is it that you want to hear? When I witnessed firsthand what you did. So they are trying to transpose a court environment into a disciplinary forum of the National Assembly. And they are two different type of institutions, structurally different, constitutionally different, and legally different. And that is what they don't understand. So let me put to rest this contention of theirs that they were not afforded natural justice, and they were not afforded a fair hearing, and they were not afforded due process. In so far as those concepts apply to the Parliament, and so far as due process and procedures are laid down by the standing orders, those standing orders were scrupulously followed. Parliamentary norms and practices, insofar as they speak to hearings before a Privileges Committee, they were copiously and scrupulously followed. So I want to reject out of hand this wild, reckless, and baseless contention of theirs that they were not afforded a fair hearing. They were afforded a fair hearing in accordance with parliamentary process and procedures. And that is what we are required to do in that Parliament. And let me say that the same thing happened to Bishop Edghill just a few years ago. The Speaker, from the floor, he did not even get to go to the Privileges Committee. The same thing was done to Sherrod Duncan, and not one of them complained about Duncan. Not one of them complained about the very Duncan. He was suspended by Speaker Mansour Nadir in this current Parliament before he was suspended again before the Privileges Committee. The Speaker used the summary process called upon him and suspended him right there. He didn't get no hearing because the process doesn't allow for that. Which one of them filed a case about Duncan? Which one of them complained about Duncan? The same treatment was meted out to Bishop Edghill, I believe in 2018, when Speaker Scotland, on the floor of the Parliament, suspended him. The question of natural justice did not arise. These are powers that a Parliament has. So don't let them cry tears and try to win sympathy out there. And they have gone to the courts, as they like to do, and we will wait and see how the court will treat with them. We will wait and see. We don't have to wait very long, but we will wait and see. And you will see how vindicated the statements I am making now will be. Well, I don't want to predict, but that's what I'm saying at this point in time. So I wanted to say that. I also want to update you on the criminal charges that are pending in the magistrates' court that were filed arising out of the 2020 general and regional elections. Now, many persons on this very program have commented requesting information about those charges. Many persons in the newspapers of our country and on social media have been asking questions about those charges. Many persons, as I walk the streets of this country, have made inquiries about those charges. And you will note that I have deliberately stayed as quiet as possible in relation to those charges because I am allowing the system to work. Now, it is important that I say that these charges are of utmost importance to the state of Guyana. They arose out of a constitutional process of the highest importance, which is our national and regional elections. The allegations upon which these charges are predicated are grave and serious. The evidence upon which these charges are grounded are of the nature and type that public officers who were being paid to work in the system, the electoral system of the country, to protect, preserve, and defend that system, who are being paid by taxpayers' dollars to ensure the democratic credentials of our country are preserved and protected, became rogue and attempted to compromise and pervert that very system that they are supposed to manage, and ensure works properly to deliver fair, credible, and transparent results. So, when actions like that are committed or are allegedly committed, it is the very state of Guyana that is under attack. And therefore, the state of Guyana has a responsibility to ensure that these matters are investigated properly, and if charges are to flow from those investigations, those charges are brought to the relevant courts and are heard and determined within reasonable time and in accordance with evidence and the applicable law. That is the responsibility of the state of Guyana to the people of Guyana. The victim here is the people of Guyana and the state of Guyana. Those are the victims in this legal matrix. Now, as the Minister of Legal Affairs, as the Attorney General, as the Minister with responsibility for and over the justice sector, it is my responsibility to speak out when the cases are not being processed, they're not being heard, and they're not being determined with the alacrity that they deserve. You are right to ask me the question, because I am publicly answerable for these matters to you, to the Parliament, and to everyone else. 32 criminal charges have been filed against various persons, and they have been filed and are pending in the magistrates' court for nearly 2 years now. For nearly 2 years now. Granted, some charges were added subsequently, and there were amendments made subsequently. Statements were served already by the prosecution to the defense. All the statements of poll that GCOM refused to give, that political parties who claim that they win the elections refused to produce, prosecutors went to the Chief Justice and got an order directing GCOM to release those statements of poll into the possession of the court, and then got permission from the court to give it to the defendants' lawyers. That was done. 1 truckload of statements of poll were already delivered. These cases are being prosecuted by the DPP, an independent constitutional office holder, who, to her credit and in recognition of the importance of these charges, hired private prosecutors to prosecute them. I have had conversations with the DPP, and the report is that magistrates within the system are not proceeding with the matter with the seriousness and the expediency with which they should, having regard to the importance of the matter and having regard to the length of time that the matters are pending before them. Magistrates have made applications to recuse themselves, and some are simply not determining whether the cases should be tried summarily, meaning in a magistrate's court, or should be taken indictably before a judge or a jury. That's a decision that magistrates have to make. It's a procedural decision that has to be made to determine how the cases will move forward. Magistrates have not been making that decision. One magistrate has made a decision that the matter be taken indictably, and that particular matter is being appealed. But there's only one charge out of 32. I have made strong representations to the DPP because, as I said, that office is in charge of the prosecution. And I have expressed my concern about the pace at which these cases are being dealt with in the magistrate court, or the lack of pace. And I have requested of the DPP most respectfully to ensure that the appropriate representations are made to ensure that greater alacrity is brought to these matters, and that they are treated with the type of seriousness that they deserve. So I thought that I will give you an update, and I hope that what I say here is not twisted or misinterpreted to mean that I am being unduly critical to any magistrate, or that I am ascribing improper motive to any magistrate, or that I am bringing the administration of justice into disrepute, or that I am trying to, in any form or fashion, influence the outcome of any case, because I am doing no such thing. And I want to make that abundantly clear. I am expressing views that I am duty-bound to express as the minister positioned where I am. And my views are carefully constructed and expressed. So I thought that I would put out in the public domain as an update where we are with those criminal charges, as you have been asking repeatedly, and it is my duty to update you, and I've done so. We continue to do our outreach as a government across the length and breadth of our country. Not all ministers, beginning of course with His Excellency, and you would have seen that His Excellency was, I believe, in Siparuta on Saturday. I was at Golden Grove, Nabakalis, doing a follow-up meeting with the residents of that locality to address the specific issue of regularizing the backlands of those villages that are so instrumental for farming in particular, which is an important economic activity for those villages, the village economy, and the villagers. So I took with me officials from the Lands and Surveys Commission and officials from the Ministry of Legal Affairs, and we had a good meeting, and we planned a roadmap on how we will proceed to bring regularity to the persons who are essentially squatting on those lands. So at the end of the day, they will end up with a formal paper title, either a leasehold title or a registered title in relation to those lands. That document they can transmit to their heirs, their children, their beneficiaries. They can assign it, they can transfer it, they can sell it. They can also use it as collateral at the commercial banks to borrow money, or at lending institutions to borrow money. That is empowering people. And that is what we are doing in relation to the residents of Nabakalis and Golden Grove, as we promised to do on a previous occasion. I heard Mr. Norton at a press conference say, today I believe, that I went to, the word he used is piai my mouth. Piai my mouth at Nabakalis. But don't worry, he was there. I don't know whether he was there, but I want him to tell you and tell the people and tell Guyana what he was there to do and what he accomplished for the people when he was there. That is what I want him to say. I have just told you that I have begun a land tenure regularization process for the people of the Bacalus and Golden Grove that will result in giving them paper title for the land that they're occupying for decades as squatters. That is what I am offering. That is what I will deliver on behalf of our government to the people of that locality. Let him tell you what he will deliver to those people. And then you will realize who and do the pia. All he went there to do, as he has done his entire life, is to politic. Let Aubrey Norton tell this country a singular initiative that he has done for any single village in Guyana. One single initiative. He will tell you that he has been in the trenches and that he has been in politics since he was a teenager, and I don't doubt that. Well, he's now 66. And I don't disrespect old people. But let him tell you, from being a teenager to now that he is in his 60s, one single thing that he has done for any community in Guyana. And he can't say it. He can't. But he got a lot of fight talk. This one must resign. This must happen. That must happen. And as I am on him, let me continue. I have listened to the most fairy tale press conference held by Aubrey Norton. He has a 10-point plan. This guy just he just entered the planet Earth from another planet. The man has 10 of the most idealistic measures. I don't know how anyone can be achieved. But he has them. That is his 10-point plan. And you would believe, as I said, that he fell from space. That his government was not in office from 2015 to 2020. He wants to divorce himself completely from his government and completely from his party, but yet obtain the benefits of being part of the party. So he's throwing the party continuously under the bus. But he is between a rock and a hard place because they never did anything either. So while we want to sit on the vehicle of the party, the same vehicle is a non-achiever. So he has a problem. He wants to ride the same vehicle, but he wants to distance himself at the same time. Well, he can't suck cane and blow whistle at the same time. His grandmother would tell him that. So the man was boasting about UG, free education at UG. But when his government was in power, they imposed fees, increase in UG fees by 35%. 35%. And this guy is now telling us about free UG fees. Job creation for young people. Promise, big promise, job creation for young people. But when his government was in power, his president said that they're not in the business of creating jobs. That young people got to go at Starbrook Market and sell sugar cake and plantain chip. Is that I who said so? Is his predecessor, his president who said so? He's now speaking about computers, that every child should have a computer. But when they got into government, they abolished, they scrapped our government one laptop per family program. One laptop per family program, they scrap it completely. Now the man is speaking about cash grant, and cash grant must be done fairly and equitably. But when they were in government, they scrapped the cash grant program. They scrapped the cash grant program. He's speaking now. He says among his 10-point plan that they will give pensioners subsidies. They will give pensioners subsidies. Well, when they were in the government, they took away the subsidies that the PPP were given to pensioners for water and electricity. He said, I will remove all that from education. Education must be tax-free, but it is they who put VAT on education. It is they who put VAT on education. Then he spoke about land must be given to the people. Well, it is his government that took away lands from the people. It is his government who took away lands from the people. He spoke about the importance of agriculture, that agriculture must become the backbone of the economy. Well, in their government, agriculture performed their worst. For the first time in Guyana's history, they put duty on agricultural equipment. Even Boredom didn't do that. They put VAT on agricultural equipment. They increased land rents and rates by 1,500% at MMA and at all state land agencies. This guy is hopeless. Completely hopeless. When you listen to him speak about his policies, you realize that this man is in La La Land. He is dreaming. He is living another reality. Because every single thing he says, they did the very opposite. The exact opposite when they were in government. And that is the party that he leads. So, you have to deal, and you know what is important? The Guyanese people are seeing him and seeing them every day. So I want him to hold more press conference. So I remember something now. Last week, he says that he wants a new list of electors. Having, obviously with a week of hindsight and realizing his error, that a new list is not possible, he now says that he wants a clean list. So the reporter asked him, bright reporter, I don't know who the person is. The reporter says, but Mr. Norton, there is a court order that says that you can't remove persons' names who are on the list. So, how is it that you're going to get this clean list? Because you're claiming that the list is bloated. He says, firstly, let me make this point. The court case that you're speaking about was done in a particular context. That's the first point. So let's give him the benefit of the doubt. Whatever context he was speaking about, I don't know. I did the case. I know what context it was. It's in the very context of a list and removing people's name from a list. But let us say, okay, get away with that kind of smart argument. The girl said, okay, so tell me how you want to remove the names. He said, I can't tell you. The PPP watching the press conference. He said, the PPP watching this press conference is a matter of political strategy. You want me to tell you for them to hear? I'm not going to do that. At the appropriate time, I'm going to do what I have to do. Bluff. He can't answer the girl question. He cannot answer the question. And then he makes up this ridiculous argument that he can't say it. No, half of this country or more voted for the PPP. So if you don't want to hear the PPP, if you don't want the PPP to hear what you're saying, why are you holding a press conference? Half of the people who would be listening to you are PPP, or you don't want us to listen to you. You don't want half of the country to listen to you, and you say you want to cross over votes. I thought you said you want to work in the other communities. Well, you say communities. I thought you want to work in the other communities. But you don't want us to listen to your press conference? You got remove. How you will get people name off the list and how you will clean the list is a secret? Look. Anyhow, so that is Mr. Norton and his press conference. Importantly, this week, on the 23rd, the Chief Justice will be ruling, I believe it's next week. When is the 23rd? Next week. The Chief Justice will be ruling on the consultation case. Remember, they took the government again to court. This time they said that the president did not meaningfully consult with Mr. Norton for the appointment of the chairman of the Police Service Commission and the Integrity Commission. Now you should understand how the Police Service Commission is appointed. The Appointments Committee of the Parliament under the Constitution is required to go out and get names, consulting with various bodies. 4 names were processed by that committee, the Appointments Committee of the National Assembly. It's made up of 5 government members, 4 opposition members. So 4 of them are sitting there. They consensually agree to the 4 names. 4 names. Those names are then taken to the outer parliament, the National Assembly. At the National Assembly, those names are voted on. So those very 4 names that came from the Appointments Committee went to the National Assembly and were voted on, including a vote coming from Aubrey Norton. Those 4 names are then sent to the President for appointment as members of the Police Service Commission. Up to now, the President plays no role, none. So 4 names are sent to him as a fait accompli. Note, Norton played a role already. He voted for those 4 names to reach to the President. So he has an upper hand over the President. And 4 members of his party sat and brought these names from the Appointments Committee, sat in that committee. The Constitution further requires that when it comes to the chairman of that commission, the Police Service Commission, the President now must take one of the 4 and consult with the leader of the opposition. One of the 4. The very 4, not coming out and bringing a new person. One of that 4, the 4 that Aubrey Norton already knows, months before, long before it reaches the President. And Mr. Norton wants the President. 4 letters were exchanged. 8 letters, sorry. 4 from this side and 4 from that side, between the President and the leader of the opposition. All he wants CVs. He approved the people in the Parliament already. He approved all of them in the Parliament already. I don't know how he did. He got his names for the Judicial Service Commission are also in that group. And names for the Teaching Service Commission are also in that whole consultative agreement or arrangement that they have challenged in the court. So once these challenges are completed, hopefully we can move swiftly to appoint these very important commissions. Well, the Integrity Commission has been appointed and the Police Service Commission, but they are now under challenge. But the new ones have to be appointed. The names are still in the same bundle of names. So, and we're part of the same process. So hopefully we are able to do that shortly, and the President will be able to appoint these important constitutional commissions that are so needed for the constitutional architecture of our country to move smoothly. We have judges to appoint, we have magistrates to appoint, we have teachers who are leaving and they can't get promotion, we have teachers who have to be hired, you have no public service commission, nobody can be disciplined, nobody can be promoted, and this is where political games are being played. Rather than accept the seriousness of the responsibilities that devolve upon the opposition leader, this guy gets into all kind of petty exchanges, refusing to shake people's hand, bowing weirdly, all kind of machinations, rather than concentrate on the important official functions that he's required to perform under the Constitution and the various pieces of statute. So we are in a serious problem here with having an opposition leader who doesn't seem to appreciate the importance of the job. I don't think he has I don't think he's able to get over the honeymoon. He's still riding on this cloud nine that he's the opposition leader. Apparently he never anticipated achieving this high post. But somebody should really bring him back down and say to him, look, you are an important person. Get over it. You have important work to do. Apparently he has not mentally adjusted to that. So we have very crucial functions, very crucial duties which are to be performed, and that would lead to the establishment of important institutions of our country are not being done, and these institutions are languishing. So my operator is signaling to me that we are running out of time, so I want to thank you very much and permit me again to apologize for the technical hiccup that we had in the commencement of this program, but we had to innovate. I hope that I get that problem fixed. I've had several technical personnel looking at it, but hopefully I get it fixed for next week. I want to thank you very much for spending the past hour or so with me, and until we meet again next week, take care, be safe, enjoy the rest of the evening and enjoy the rest of the week. Thank you very much for your attention.